The Committee on Science, Space, and Technology will come to order. Without objection, the Chair is authorized to declare recesses of the committee at any time. Welcome to today's hearing entitled Investigating Contract Misconduct at the National Weather Service. I'll recognize myself for an opening statement and then recognize the ranking member. Today we will hear about the Department of Commerce Inspector General's recent report on alleged contracting misconduct and improper influence at the National Weather Service. The Committee on Science, Space, and Technology has primary jurisdiction of the National Oceanic and Atmospheric Administration and the National Weather Service. Accurate and timely forecasts help keep Americans safe from extreme weather events. But this vital work is undermined and taxpayer money is wasted when senior officials at the National Weather Service, NOAA, and the Department of Commerce are apparently complicit in granting improper contracts. Today's hearing is an opportunity to hear from Mr. Donald Huron, the former Deputy Chief Financial Officer at the National Weather Service, and Mr. Robert Byrd, the former Chief Financial Officer at the National Weather Service. These two individuals have the opportunity today to truthfully tell us why taxpayers picked up the tab for an allegedly improper contract worth nearly $500,000. There is something fundamentally wrong with a system that allows a government employee to draft their own post-retirement contract, which increases their salary and pays for their housing while being funded by American taxpayers. Furthermore, in this case, the National Weather Service hired a replacement for Mr. Huron, who ended up duplicating the work Mr. Huron was doing as a contractor. So after paying Mr. Huron more money each month as a contractor and also paying a new deputy CFO, American taxpayers essentially paid 3 times as much for the same work formerly done by one person. Somehow the National Weather Service was not aware of this issue until Mr. Huron allegedly bribed a government employee to get a family member a job, which led the Office of Inspector General to open an investigation. Although there is no legal issue in the vast majority of cases that involve federal employees who return to work as contractors, I am concerned that this type of inappropriate revolving door problem might be common at the National Weather Service. Mr. Huron and Mr. Byrd were invited here today to explain what happened. Unfortunately, both former senior officials chose non-cooperation over being forthright. Both refused to speak with committee staff voluntarily and only appeared here today after the committee had no alternative but to issue a subpoena. I still hope that Mr. Huron and Mr. Byrd will take the opportunity today to address the charges made in the IG's report. One of the most important functions of Congress is to conduct oversight of the executive branch. This provides the fundamental checks and balances that our founders intended. When Americans' trust has been violated, Congress has an obligation to understand what went wrong so we can ensure that it does not happen again. I was disappointed to learn that despite the OIG's findings, the Obama administration's Justice Department refused to investigate this case. In fact, the DOJ rejected the IG's recommendations to investigate. So I look forward to hearing from all 3 witnesses this morning to shed more light on these allegations. And that concludes my opening statement, and the gentlewoman from Texas, Ms. Johnson, is recognized for hers.
Thank you very much, Mr. Chairman. Today we're holding a hearing entitled Investigating Contract Misconduct at the National Weather Service. I'm afraid that much of this hearing will be, unfortunately, theater rather than real oversight work, and I regret this. Before I touch on that again, I do want to speak to the Inspector General's report, which is the genesis for this hearing. Now, I certainly do not support misconduct by government officials. However, it looks like the problems uncovered in this report are less about the specific conduct of one individual than the failure of judgment and oversight up and down the management chain in the National Weather Service. It is widely known in the NWS that Mr. Giron, the Deputy Chief Financial Officer, was going to come back as a contractor after retiring. No one intervened to stop him from writing his own statement of work. They even suggested that he do it and others in the office actually helped him by reading and commenting on this statement of work. It was also common knowledge in the office that NWS was paying for his housing costs while he was a contractor, and no one ever raised a question about this or attempted to revise the contract. That no one knew to stop Jerron from doing those things is more concerning to me than his personal actions. This kind of systemic failure is disappointing and something we should hold the NWS to account for. However, we do not have any current NWS officials here today to discuss how they plan to proceed in the future or what steps they already have taken. Instead, we have two retired NWS employees who were compelled to attend this hearing by congressional subpoena, despite the fact that they have both indicated that they plan on exercising their constitutional right to not speak here today. I'm not sure an issue with a single post-employment contract is worthy of this spectacle, Mr. Chairman. I want to be clear that I'm not defending these gentlemen's conduct to the degree that we understand it, but I question the aggressive action of this committee when the chairman has been reluctant to act in other areas. The systemic failure of NWS is matched by a different systemic failure in the Commerce EIG's office. That office received allegations regarding Mr. Jerron's action in January 2012. By August 2012, the IG was briefed on the findings, and nearly 20 interviews had been completed. The report was essentially done at that point. Then it died. Nothing happened with this case for years. Then almost 2 years later, the IG rushed to issue this report. At about the same time, the IG's office was being investigated by this committee. While this report may be 100% accurate, and Mr. Greenblatt may have done a public service in shepherding the report to completion, I have to look at the timing of the report's release and with some skepticism, knowing that the report was revised at a moment that saw the leadership in the office looking for sensational products to convince this committee to drop a bipartisan investigation of the former IG Todd Zinsser and his office makes me question the product. I think it is worth reminding the members of this committee about that investigation of the IG's office. The investigation began as a bipartisan effort. It included 3 bipartisan letters from the committee, including 2 document requests. It included a number of staff interviews of Commerce IG employees, and it included the establishment of a network of whistleblowers providing information to the committee. This investigation bore much fruit. It uncovered a pattern of whistleblower intimidation and retaliation by the Inspector General Todd Zinsser and his deputy, Morgan Kim. It uncovered evidence of gross mismanagement of the office, some of which likely violated federal law and regulations. It uncovered possible false statements to Congress during Mr. Zinsser's confirmation process. Perhaps more importantly, it uncovered extensive evidence of Todd Zinsser and Morgan Kim's personal efforts to obstruct the committee's investigation. This evidence led me to ask the President to remove Mr. Zinsser from office. I'm attaching that letter and my March floor statement outlining the results of this investigation, as well as our past letters to my statement today. This evidence led the chairman down a different path. The chairman pushed the investigation over to the Council of Inspectors Generals for Integrity and Efficiency, the CG. However, we have it on good authority that the FBI sought information to support the chairman's letter to the CG on 2 separate occasions, and the majority staff did not respond, leaving the CG investigation to die a quiet death. It is confusing to me that on the one hand, the chair quietly tolerates the most obvious and well-documented obstruction this committee has seen.
The gentlewoman's time has expired. However, she is recognized for an additional minute.
Thank you. I want to finish my statement. while on the other hand, the chair has issued more subpoenas in the past year when the previous 6 committee chairs combined. And last week, the majority accused the EPA of obstruction based on 0 supporting evidence of those claims. I wish this committee would focus a little less on political theater and a little more on real documented wrongdoing. I'm sending the acting Commerce Inspector General a letter instructing him to retain all records in anticipation of my sending a referral to the Department of Justice regarding criminal misconduct by the former Commerce Inspector General and others in the coming days. I will send that referral to the Department of Justice, and I would welcome any of my colleagues who wish to engage in a real oversight to join me in that letter. Thank you, and I yield back.
Thank you, Ms. Johnson. I'll introduce our witnesses.
Mr. Chairman, point of order.
For what purpose does the gentleman seek to be recognized?
Point of order.
And he will state his point of order.
Point of order is the witnesses have rights pursuant to the Constitution, Fifth Amendment, rules of the House, and the Jefferson Manual, do they not?
They do.
Point of order, Mr. Chairman.
And your point of order is?
Pardon me?
Would you state your point of order?
Point of order is these witnesses have 2 witnesses, Mr. Byrd and Mr. Huron, have advised this committee that they intend to take the Fifth Amendment against self-incrimination.
That may well be the case.
Is that true? Have they advised this?
We will see what they decide to do momentarily, and I think you will not be surprised if they do seek the Fifth Amendment.
Okay. Point of order.
This gentleman will continue to state his point of order.
Point of order is that they cannot be compelled to testify against themselves by this committee or a court of law if they have taken the Fifth Amendment.
That's my understanding as well.
Okay. Point of order.
Please continue.
Point of order is to advise the attorneys on this panel that if someone has taken the Fifth, that as an attorney we have additional responsibilities under our rules of professional conduct, at least in Colorado and as in the D.C. bar, to not embarrass, humiliate, or degrade a witness who has exercised their constitutional rights pursuant to the Fifth Amendment. Is that not true?
That is also the case.
Okay. I yield back.
Okay. Thank you. And we will continue. Our first witness, Mr. Greenblatt, is the Deputy Assistant Inspector General for Compliance and Ethics for the Department of Commerce Office of Inspector General. Prior to his tenure at the Inspector General's office, Mr. Greenblatt held the title of Investigative Counsel, Deputy Chief Counsel, and later Minority Staff Director and Chief Counsel on the U.S. Senate Permanent Subcommittee on Investigations. Mr. Greenblatt earned his bachelor's degree from Duke University and his J.D. from Columbia University School of Law. We welcome him. Our next witness, Mr. Robert Byrd, formerly served as the Chief Financial Officer for the National Weather Service. Mr. Byrd holds an MBA with honors from Loyola College of Maryland and has completed postgraduate MBA programs at Syracuse University and Harvard Business School. Our final witness, Mr. Huron, is the former Deputy Chief Financial Officer for the National Weather Service, and he has not provided us with any further information. It is not the Science Committee's practice to swear in witnesses at hearings. However, both Mr. Huron and Mr. Byrd refused to sign the committee's False Statements Act certification form, so I believe administering the oath to them is necessary at this time. And would Mr. Huron and Mr. Byrd please rise?
Mr. Chairman, one more point of order.
Hands. The gentleman will state his point of order.
Another point of order. Pursuant to the Constitution, these gentlemen are entitled to have counsel to assist them at this hearing, are they not?
If they wish, they have that right, and I believe they do.
One more point of order, sir.
Yes, state your point of order.
Must they, having given notice to this committee that they intend to take the Fifth Amendment, must they remain here for purposes of taking this oath?
If they take the Fifth Amendment, they will be excused.
Okay. I yield back.
Okay. Thank you. Mr. Huron and Mr. Byrd, will you please rise and raise your right hands? Thank you. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect that the witnesses answered in the affirmative, and please be seated. Mr. Greenblatt, we look forward to your testimony, and please proceed.
Chairman Smith, Ranking Member Johnson, members of the committee. We appreciate the opportunity to testify today. Last month, the Department of Commerce Office of Inspector General issued a report detailing our investigation into allegations of impropriety involving a senior National Weather Service official who became a consultant to the agency immediately after his retirement. Our investigation identified a number of problems related to the retention of this senior official. With regard to the senior official himself, the evidence established that he was personally and substantially involved in the procurement of his own post-retirement consulting services. Specifically, the evidence established that while he was still a federal employee, this senior official, 1, drafted and edited the statement of work for his consulting position, 2, participated with National Weather Service officials in setting his future rate of pay, and 3, signed the task management plan that authorized the consulting work he would later perform. Notably, he signed this task management plan while he was still a federal employee as, quote, contractor POC, the contractor's point of contact. This involvement implicated several federal laws and regulations, including the Criminal Conflict of Interest statute found at 18 U.S.C. 208. Additionally, evidence established that this senior official took inappropriate steps to arrange for the National Weather Service to pay for his housing expenses for his post-retirement consulting position, which amounted to nearly $52,000. The evidence also established that after he became a contractor himself, the senior official contacted several National Weather Service officials in an attempt to secure another contracting position for an immediate family member. We concluded that the senior official's actions in attempting to influence the NWS staff were improper, and in one case may have implicated 18 U.S.C. 201, the criminal statute prohibiting bribery of public officials. As a result of our investigation and our initial briefings with senior NOAA leadership, NOAA took immediate action to stop work on the senior official's task order in early 2012. In total, the senior official's post-retirement work as a consultant lasted 21 months and cost the government more than $471,000. While the OIG's inquiry focused on this senior official because he was identified by name in multiple whistleblower complaints, we nonetheless concluded that several other government officials share responsibility for the problems we identified. In particular, evidence indicated that the subject acted at the direction and with the approval of his supervisor at all times. 2, the subject's consulting arrangement was facilitated and approved by other officials with responsibility for ensuring integrity in government contracting. Further, statements from several witnesses indicate that it is not uncommon for National Weather Service employees to retire and then come back as contractors to perform similar duties. For example, a high-ranking official at NWS wondered aloud during her OIG interview, quote, why we have all these people that retire and then we go and hire them to come back. Similarly, a representative of NOAA's Acquisition and Grant Office, which is responsible for approving NWS contractor positions, indicated that federal employees returning as contractors once they retire, quote, happens all the time. In fact, the NWS supervisor in this case told us that he did not see any problems with the arrangement because he, quote, sort of got the sense that this is just the way business is done. Comments such as these indicate that there may exist a revolving door practice at NWS that created an environment in which problems that we identified in our report could occur. With this in mind, the OIG is now taking steps to assess whether a revolving door practice truly exists at NWS. For example, on June 11th, we initiated an audit of NWS's award and administration of procurement actions that support its workforce. The overall objective of this audit is to evaluate whether NWS has adequate controls in place to ensure compliance with applicable laws and regulations for personnel support acquired through service contracts. As part of this audit, we will assess how many former employees NWS may have retained as contractors within the last several years. Through our investigative and audit efforts, we will examine how often such hirings occur, whether they comply with relevant contracting and ethics regulations, and whether there are any programs, offices, and areas that may warrant closer scrutiny. I want to thank the committee for the opportunity to testify today, and I look forward to your questions.
Thank you, Mr. Greenblatt, for your testimony. Mr. Byrd, you have now provided the committee with a written statement. Do you wish to make a statement at this time?
Thank you, Mr. Chairman. My name is Robert Byrd, and I've been compelled to appear before this committee by subpoena. On advice of counsel, I respectfully exercise my Fifth Amendment right not to testify.
Okay. I have some questions, and then we'll look forward to your response. Do you? The gentleman will state his point of order.
Upon taking the fifth, he may leave at this point in the hearing, may he not?
He has to establish that he is taking the fifth by.
Right. The gentleman is incorrect. The witness needs to establish that he has taken the fifth by his response to some questions that I intend to ask.
Mr. Chairman,
Yes.
point of order. The witness has already established that he's taken the fifth. By your questioning him, you are putting him in a position where you're trying to set up that he will waive his right, and I object to this. That's not what we're
Okay. To respond to the gentleman's point of order, the Fifth Amendment does not provide blanket immunity from all committee questions. And if the gentlewoman and gentleman will listen to my questions, I think they'll understand, since they're both lawyers, why I need to proceed to ask these questions.
We'll do so with interest, but don't be surprised if I do a point of order or two between your questions.
The gentleman is
Likewise,
always
Mr. Chair.
free to raise a point of order. Mr. Byrd, were you the Chief Financial Officer for the National Weather Service?
Upon advice of counsel, Mr. Chairman, I respectfully exercise my amendment right, my Fifth Amendment right, and decline to respond.
Let the record reflect that Mr. Byrd has asserted his Fifth Amendment right against self-incrimination. And Mr. Byrd, please let me be very clear. Are you declining to answer the committee's questions solely on the ground that you believe the answer will incriminate you?
Point of order, Mr. Chairman. Under the Fifth Amendment, he does not have to answer that.
Okay. That, I am told, is not a valid point of order, and I'm going to direct the witness to answer the
Mr. Chairman,
question.
point of order.
The gentlewoman will raise a point of order.
I request that if Mr. Byrd now would like to, he may consult with his attorney.
He is always free to consult with his attorney, and that's not a legitimate point of order. Mr. Byrd, would you answer my question? Let me repeat it. Are you declining to answer the committee's questions solely on the ground that you believe the answer will incriminate you?
On advice of counsel, I respectfully exercise my Fifth Amendment right not to respond.
And was Mr. Huron your Deputy Chief Financial Officer at the National Weather Service?
On advice of counsel, I respectfully exercise my Fifth Amendment right and decline to respond.
Okay. And did you approve Mr. Huron's post-retirement consulting contract?
Point of order, Mr. Chairman.
Another point of order. The gentleman will
Point of order. This is the point of order that I raised initially, that under the rules of professional conduct for the District of Columbia, as well as Colorado, I assume Texas, that under Opinion 31 of the District of Columbia, in Colorado it's 8.4H, that to continue to pursue a line of questioning where a witness has taken the Fifth Amendment can be considered to be offensive, abusive, and harassing conduct not calculated to lead to admissible evidence.
The gentleman has not taken the Fifth Amendment on every aspect of every question, and I have two more questions for him. At that point, he will be allowed to be dismissed.
Okay.
Mr. Byrd, two more questions, or three, actually. Did you approve Mr. Huron's post-retirement consulting contract?
Upon advice of counsel, I respectfully exercise my Fifth Amendment right and decline to answer.
And did you approve $50,000 worth of housing benefits received by Mr. Huron, paid for by the National Weather Service?
Upon advice of counsel, Mr. Chairman, I respectfully exercise my Fifth Amendment right and decline to answer.
And my last question is this. Is it your intention to decline to answer all questions put to you today by the committee on the basis of the Fifth Amendment right against self-incrimination?
Upon advice of counsel, I respectfully exercise my Fifth Amendment right and decline to answer.
Ms. Byrd, your testimony is essential to this hearing and to the committee's Article I oversight and information gathering functions with regard to contracting misconduct and exertion of improper influence at the National Weather Service. The committee is entitled to probe the basis for your Fifth Amendment privilege assertion, especially as the Fifth Amendment does not provide blanket immunity from all questions by the committee. The committee specifically directs you to answer the question, notwithstanding your objection. Did you approve?
Point of order, Mr. Chairman.
$50,000.
Point of order.
Gentleman is not recognized at this point. Did you approve $50,000 worth of housing benefits received by Mr. Huron, paid by the National Weather Service? The gentleman is now recognized for his point of order.
Point of order, Mr. Chairman. The gentleman has taken the Fifth Amendment with respect to every question that the chair has submitted to him. Point of order, that he is entitled at this point to his counsel, and I guess I am, to say that this is now harassment, given the fact that he has said he's going to take the Fifth Amendment and that he should be allowed to leave pursuant to the rules and the Constitution of the United States.
My response to the gentleman's point of order is that what we are doing is under the advisement by the House General Counsel. And once again, the Fifth Amendment does not provide blanket immunity to all questions, and many of the committee's questions fall outside of subjects over which you may legitimately claim a privilege.
Point of order.
And the gentleman will state another.
Rule 9, Clause 2 of the Rules of the House of Representatives and Jefferson's Manual 341, 342, 343 allow a witness to not answer and does not have to respond to questions pursuant to the Constitution, and the ethical rules that attorneys are bound by have to respect those particular rights of a witness.
Right.
And to continue this line of questioning, I would say to the chairman, is degrading and embarrassing and not calculated to lead to admissible evidence, and therefore this witness should be allowed to leave at this point.
To respond to the gentleman's point of view, the witness can answer my question any way he wants to. He can refuse to answer it. He can plead the Fifth Amendment. But in any case, we are, again, proceeding in accordance with the recommendation and the advice of the House General Counsel. And if it makes the gentleman feel any better, this is probably the end of my questioning, but again, there is a reason for establishing this for the record. And once again, and finally, I want to ask the witness, did you approve $50,000 worth of housing benefits received by Mr. Huron, paid for by the National Weather Service?
On advice of counsel, Mr. Chairman, I respectfully exercise my Fifth Amendment right and decline to answer.
Okay. Mr. Byrd, please be advised that you have a choice here between complying with the committee's directive and answering the question or refusing to do so, which will place you at risk of a contempt citation, potentially a prosecution for contempt, and criminal liability. Do you understand this?
On advice of counsel, I respectfully exercise my Fifth Amendment right and decline to answer.
The Fifth Amendment does not provide blanket immunity from all committee questions. Indeed, many of the committee's questions fall outside of subjects over which you may legitimately claim privilege. Additionally, by refusing to answer the committee's questions, we cannot assess the legitimacy of your Fifth Amendment assertion. You are directed to answer the question, and again are advised that the failure to do so may result in a contempt citation and criminal liability.
Point of order.
The gentleman will state his point.
Point of order. The witness has rights, does he not?
The gentleman will state a legitimate point of order.
Point of order is the witness has rights pursuant to the Fifth Amendment to Section Article 11, Clause 2, Sections 341, 342, 343 of Jefferson's Manual, does he not?
Of course, the gentleman and the witness has rights.
Okay. So the gentleman has asserted his rights, and the chair's continued interrogation is probably beyond the pale of Opinion 31 and the rules of professional conduct, as well as the rules of the House of Representatives. And at this point, I would ask the chair, can the witness leave?
The gentleman has not stated a legitimate point of order, but I'm still going to respond by saying I have one more question for the witness, and frankly it is my responsibility to advise the witness of the consequences of his refusal to answer the questions. That is a legal responsibility on my part, according to the General Counsel of the House. I have one final question for the witness. Knowing what I've just said, will you answer the committee's question as directed, or do you refuse to answer the committee's question?
Upon advice of counsel, Mr. Chairman, I respectfully exercise my Fifth Amendment right and decline to answer.
Okay. Ms. Byrd, you will be excused momentarily, but I want to next address some very similar questions to Mr. Huron, and then I would expect you both to be excused. Mr. Huron, you have not provided the committee with a written statement. Do you wish to make a statement at this time?
Yes, Mr. Chairman. On the advice of counsel, I respectfully decline to answer on the basis of the Fifth Amendment, which, according to the United States Supreme Court, protects everyone, even innocent people, from the need to answer questions if these answers might be used against them in a criminal prosecution.
I understand, and you've just heard me ask some questions to Mr. Byrd. I'm going to ask you very similar questions. They are on different subjects, and it's because the Fifth Amendment is not blanket immunity. Mr. Huron, prior to your retirement from the National Weather Service, did you hold the position of Deputy Chief Financial Officer at the end of your 38-year duration as a public employee?
As I said before, on advice of counsel, I'm invoking my constitutional right not to answer.
Right. Let the record reflect that Mr. Huron has asserted his Fifth Amendment right against self-incrimination. Mr. Huron, please let me be very clear. Are you declining to answer the committee's questions solely on the ground that you believe the answer will incriminate you?
Point of order.
Gentleman will state point of order.
Point
but
of
he's
order is
likely to get the same answer I gave him a while ago, but he can still state a point of order.
Point of order. The witness, upon having already asserted his Fifth Amendment rights, does not have to proceed in this fashion to answer any other questions, and that's
a legitimate point of order, and I'll answer it as I did a while ago, and that is the Fifth Amendment, or taking the Fifth Amendment, does not provide blanket immunity from all committee questions. And that's why I will continue to ask about certain subjects, and he is willing and able and welcome to plead the Fifth Amendment if he so desires. Again, Mr. Huron, are you declining to answer the committee's questions solely on the ground that you believe the answer will incriminate you?
On advice of counsel, I'm invoking my constitutional right not to answer.
My next question is, did you return to the National Weather Service after your retirement as a consultant?
On advice of counsel, I'm invoking my constitutional right not to answer.
Did you draft your post-retirement consulting contract while an employee of the National Weather Service?
On advice of counsel, I'm invoking my constitutional right not to answer.
Your attorney said that there are material inaccuracies in the Inspector General's report. Do you concur with that?
order.
The gentleman will state his point of order.
As to what the attorney said, the examination should be of the attorney, not of Mr. Huron.
I'm simply saying what his attorney said. He can disagree or agree and answer the question any way he wants to. And once again, your attorney said that there are material inaccuracies in the Inspector General's report. Do you concur with that?
On the advice of counsel, I'm invoking my constitutional right not to answer.
Mr. Huron, is it your intention to decline to answer all questions put to you today by the committee on the basis of the Fifth Amendment right against self-incrimination?
On advice of counsel, I'm invoking my constitutional right not to answer.
Mr. Huron, your testimony is essential to this hearing and to the committee's Article I oversight and information gathering functions with regard to contracting misconduct and exertion of improper influence at the National Weather Service. The committee is entitled to probe the basis for your Fifth Amendment privilege assertion, especially as the Fifth Amendment does not provide blanket immunity from all questions by the committee. The committee specifically directs you to answer the question, notwithstanding your objection. Did you draft your post-retirement consulting contract while an employee of the National Weather Service?
On advice of counsel, I'm invoking my constitutional right not to answer.
Mr. Huron, please be advised that you have a choice here between complying with the committee's directive and answering the question or refusing to do so, which will place you at risk of a contempt citation, potentially a prosecution for contempt, and criminal liability. Do you understand that?
On advice of counsel, I'm invoking my constitutional right not to answer.
Mr. Huron, the Fifth Amendment does not provide blanket immunity from all committee questions. Indeed, many of the committee's questions fall outside of subjects over which you may legitimately claim privilege. Additionally, by refusing to answer the committee's questions, we cannot assess the legitimacy of your Fifth Amendment assertion. You're directed to answer the question, and again are advised that the failure to do so may result in a contempt citation and criminal liability. Knowing this, will you answer the committee's question as directed, or do you refuse to answer the committee's question?
On advice of counsel, I'm invoking my constitutional right not to answer.
I am disappointed that two of our witnesses refused to answer questions or provide any information to help the committee perform its oversight function. Mr. Huron and Mr. Byrd, you are dismissed subject to recall, and we will now take a 2-minute recess in order for you all to leave the room. What do you want me to read?
This was all from your closing statement. I thought we'd send this out now.
Okay, good. The committee's hearing will resume, and I'll recognize myself for 5 minutes to ask questions. Mr. Greenblatt, first of all, again, I appreciate not only your testimony today, but your investigation as well. You are doing a real public service, and you are also helping us do our job as well. My first question is this. From what I read, it may well be common practice at NOAA and at the National Weather Service for employees to write their own contracts as a consultant, leave the employee of the federal government, and then almost immediately begin work as a consultant, oftentimes doing the same job for more money. Do you think this is common practice? And if so, how are we going to determine whether it is common practice?
I would say that the common practice that we found, what the witnesses told us, related to folks leaving the Weather Service and then coming back as contractors. That whether or not they wrote their own contracts or had involvement in the procurement of their own future services, we did not get testimony on the extent of that. We did get a fair amount of testimony from folks saying that the retirement and then later contracting positions, that did happen.
Right. And are you going to continue your investigation to find out whether it was commonplace for someone to write their own contract and then retire and then become a consultant?
Well, the Office of Inspector General has initiated an audit to look at the scope of the problem, and over the course, and when I talk about what I'm talking about is the revolving door practice,
right.
How often that happened over the last few years. Once we get our arms around the problem, then I think we'll begin to dissect.
Just
and move
give
forward.
me a rough idea as to how long you think it will take you to complete the continuing investigation.
I believe the anticipated delivery date on that particular audit is December 2015.
Okay, so what, 6 months from now, roughly, we'll be able to get another report on whether that practice is widespread or not.
That's my understanding,
Okay.
yes.
Thank you. That's very helpful. It's my understanding, too, that penalties associated with the types of violations that have been alleged can be up to 5 years in prison and up to $50,000 for each violation. Is that correct?
That's under Section 208, 18 U.S.C. 208. Yes, that has that, and then that's for willful engagement
right.
in those.
The point I'm trying to make here is that these are very, very serious infractions. They may be criminal in nature, and that's why you see penalties up to 5 years in prison. These are not light, minor types of ethical or criminal violations. Have Mr. Huron or Mr. Byrd faced any kind of sanctions as a result of the allegations?
Well, once the Office of Inspector General uncovered some of the activities, particularly related to Mr. Huron's efforts to secure a position for his immediate family member, we briefed NOAA senior leadership, and they took action to terminate the work order on that particular contract.
Thank you for that answer. Also, it's my understanding that you recommended that the Department of Justice investigate themselves, and they declined to do so. Why did they decline to investigate and not, quite frankly, follow up on your own recommendations?
Well, we referred the matter pursuant to the Attorney General guidelines to the Department of Justice for consideration for their own efforts. They elected to decline to prosecute. As far as the specific reasons why, I think that would be better. They would be better positioned to provide the specific reasons as to why they declined.
Okay, their decline to prosecute was contrary to your recommendation that they investigate. Is that correct?
Well, we're obligated to refer over cases in which we believe there's a reasonable basis to conclude that there was a criminal violation.
Right. Who was the individual who was the decision maker who, in your opinion, was the one who decided not to prosecute or not to continue the investigation?
Well, we referred the matter to the Department of Justice, the U.S. Attorney's Office in Maryland, because that is where the National Oceanic and Atmospheric Administration is located.
Right. Did you talk to any individual in the Department of Justice and give a verbal recommendation?
I did.
And who did you talk to?
The individual there was an individual named James Crowley.
Okay.
He's the chief in the Southern Division of the U.S. Attorney's Office in Maryland.
So presumably he would have been the one or one of the individuals making the decision not to prosecute. Is that right?
I don't know exactly, again, who made any sort of final decision, but that was the individual that I spoke with.
Is he the individual who told you that DOJ was not going to prosecute?
Yes.
Okay. Thank you, Mr. Greenblatt. That concludes my questions, and the gentlewoman from Texas is recognized for hers.
Thank you, Mr. Chairman. I'd like to personally thank all of the whistleblowers from the Commerce IG's office who cooperated with our investigation. They risked their careers by bringing information of misconduct by the leadership of that office to this committee. I believe stepping forward to inform us of these issues, it took real courage and strong ethical principles. While I have faith in the new leadership in the Commerce's IG office to move in a much more positive direction, I also believe that this committee has an obligation to those whistleblowers who risk their careers informing us of Mr. Zinser's misdeeds and that we continue to follow through. Mr. Greenblatt, your office has had a fairly terrible reputation regarding whistleblowers because of the conduct by the former IG and his closest aides, and I hope that the acting IG, Mr. Smith, takes stronger steps to restore the reputation of this office as a safe haven for whistleblowers. Tell me what you see that's happened to improve the situation, and would you comment on the progress?
Well, I can speak to my experience. I have been with the IG for a little bit more than a year now. I believe my staff, we have a very healthy, productive environment. I think folks are happy. Folks are given the opportunity to stretch their legs. We're doing sophisticated work, challenging work. I think people are fulfilled. That's something I actually take great pride in. I hope that's a reflection of the office as a whole. But in my experience, in my perspective, we have a good thing going, and I hope that it continues in the future.
Thank you. I'm not dismissing wrongdoing by anyone, but in reviewing this case, it seems more as if we have an instance of institutional failure rather than individual wrongdoing. If any of the half-dozen officials had known better, they could have stopped Mr. Jerome from making the mistakes that he took in regards to this post-employment agreement. Do you agree that this is more of an institutional failure rather than individual misconduct?
What I would say is that it is certainly more than just an individual, certainly. There were a number of people who were responsible for stopping any kind of problems of this sort, and they just didn't catch it. Gatekeepers didn't act as gatekeepers. Supervisors didn't supervise properly. And so that's the problem. Now, institutionally, I don't know about the entire institution. I don't want to go too broad in the answer. But yes, it was certainly more than one individual. There's no doubt about that, and I think our report is very clear on that.
Thank you. Last week, the Government Accountability Office, the GAO, released a report that I'd requested along with my colleagues on the Energy and Commerce Committee. It examined the effectiveness of the Commerce IG's office. The most disturbing finding of that report was the fact that the Commerce IG's office conducted no performance audits of 8 of the agency's 13 bureaus and offices from 2011 to 2013, and that the OIG had not conducted a Federal Information Security Management Act audit for 7 of the agency's 13 bureaus in the same period of time. I hope that the new leadership in your office will be much more effective, efficient, and aggressive in your oversight work. Would you like to respond to that?
Well, I appreciate your concern. I know that we have concurred with the GAO report and are working actively to address the recommendations. I should say I'm on the investigation side of the House, so I'm not well positioned to talk about the audit side of the House, but I'm sure we can get back to you with further information if you would like on that specific angle.
Thank you very much. I would like to say that I have faith that the new leadership in the Commerce's IG office takes your oversight responsibilities seriously and will strive to correct the mismanagement issues that have crippled the effectiveness of this office in the past, and I thank you. I yield back.
And thank you, Ms. Johnson. The gentleman from California, Mr. Rohrabacher, is recognized for his question.
Thank you very much, Mr. Chairman, and I want to compliment you for trying to do something that is important. And whenever you do things that are important, you're going to get some people mad at you, and or jumping in. And let me just say that I think that you have handled yourself very well in this hearing, and I'm disappointed that people felt compelled to jump on your case, considering how important what we're examining is. We are talking about today the actual, well, I wouldn't call it embezzlement, but at the very least a waste of hundreds of thousands of dollars of taxpayer dollars. Isn't that correct?
The amount that the senior official was paid pursuant to the contract and his housing was over $471,000.
Right. That $471,000, however, if he would have stayed in government service, he would have been paid a certain amount of money then, less than that. I mean, so the actual loss to the government isn't the $471,000, but it's hundreds of thousands of dollars anyway.
Well, and if you also add on to the fact that he was getting full retirement at that point as well, on top of the wages from under the contract, yes, it was much more than $471,000 in that regard.
Okay, so if we allow things like this to go on, well, let me ask this: is this a loophole in the law? Do you see this as a loophole that someone was able to do something legally that provided them with hundreds of thousands of dollars of personal benefit, even though the government was not receiving any added service or benefit from the expenditure of that money? Is that a loophole, or is this a violation of law?
Well, there are certainly colorable reasons to have someone come back after they retire. Sometimes they do have specialized knowledge, institutional knowledge, that may warrant bringing them back. So I don't want to make any blanket statements that bringing someone back is inappropriate. That in and of itself is not a problem. It may set the stage for problems, as in this case where the individual was involved in drafting his own statement of work for his future consulting services. That's where the problem lies on that particular topic.
I actually would disagree with the last points that you made. I think that we have a serious problem in the federal government, throughout the government. It's not just this one case, but where we have people who are making decisions that would benefit themselves based on senior people who will be retiring soon are making decisions, whether the Department of Defense or elsewhere, that have dramatically bad impact on the taxpayers getting their money's worth. And sometimes it's disastrous for generals, for example, who make decisions on certain types of of weapon systems that we will use, and then going to work as soon as they retire for the company that's producing that weapon system. I would hope that, number one, that what we're doing today, and as Chairman Smith is trying to do, is sending the message that if we have an institutional mindset that sort of doesn't confront that problem, we're going to confront it now. If we are going to bring down the budget deficit, I would say the most laudatory way of bringing down the deficit is getting rid of things like this. And so if there is a mindset among government that this is an okay thing to do, even though it's costing the taxpayers an enormous amount more money, well, let's go on the record now, all of us, to say that is not acceptable. And the best way we can do that is to take cases like this, and unfortunately individuals will have to be confronted with this. And once they're confronted, the message will go out to the rest of government employees. This will save the American taxpayer perhaps billions of dollars if we do this and eliminate this mindset that I see as pervasive throughout the federal government. So I thank you, Mr. Chairman, and thank you for your testimony today.
Thank you, Mr. Rohrabacher. The gentleman from New York, Mr. Tunko, is recognized for his questions.
Thank you, Mr. Chair, and Mr. Greenblatt. Welcome. Mr. Greenblatt, our committee first started investigating the conduct of the former Commerce IG, Todd Zinsser, in September of 2012. This was soon after he testified before a subcommittee on investigation and oversight hearing we held on the Anti-Deficiency Act, or the ADA, violation at the National Weather Service. I, at that time, was the ranking member of the oversight subcommittee. At that hearing, almost 3 years ago, Mr. Zinsser referenced the case you are testifying about. Mr. Zinsser said, and I quote, "While our investigation is ongoing, we have determined that NOAA provided the contractor housing valued at more than $52,000 and spent more than $336,000 in wages for this consultant's services over a period of 1.5 years. We promptly notified NOAA of our preliminary findings concerning the consultant's efforts to secure a job for the family member. NOAA took swift action to terminate the consultant's employment with the agency," said Mr. Zinsser. So Mr. Zinsser mentioned the case you finally released in June of 2015. All of the elements were there. Staff tell me that all the work was largely done. And I realize you just came to the Commerce IG's office last year. But can you explain to us why a case the IG's office believed was potentially criminal in nature and was largely finished by August of 2012 sat unfinished for some 3 years?
I don't have a good answer for you. The delay is not good, and when we make mistakes, I'll own up to it. When I came on in May of 2014, we had an extensive backlog of cases. This was one of those cases. I was given a directive to clear out that backlog, and we put considerable effort into doing just that. We released a number of reports of significant value, and both internally and some that were issued publicly. This was one of those reports. Part of the reason this was structured as it was in the priority list is that the behavior was not ongoing. It had stopped. The contract had stopped. And so I think that was a factor in it. But at the end of the day, it should have come out sooner, and it was out effectively 1 year after I arrived at the office.
Well, the delay pattern, is this something that was a common pattern?
No, I don't think it was intentional in any way. I think...
was it a common pattern?
I think as I said, we had a backlog of cases when I arrived. A number of them were older cases. We had major staffing issues, and as part of our growth and as part of our revitalization in the Office of Investigations, We have knocked down that backlog. When I came on, there were cases from 2011 on the backlog, and now we have cases that are only as old as 2014. So I think we've done a good job on that. I don't think we're all the way there yet, but we have made fantastic progress in my view.
Okay, well, frankly, we came away from our examination of the Anti-Deficiency Act work with the impression that the office was badly managed. Hotline tips were lost or misassigned. We were aware of work that was started and then abruptly abandoned. GAO did a review of the office that found real problems in policies, in procedures, and in the scope of work undertaken by the IG. Ms. Johnson deserves credit for continuing to push for change in the office leadership. I want to reiterate her comments that we want to see the office moving out and doing a good, solid job going forward. Please take that message back from this hearing, and good luck to you as you work through your backlog. And with that, Mr. Chair, I yield back.
Thank you, Mr. Tomko. The gentleman from Oklahoma, Mr. Bridenstine, is recognized for his questions.
Thank you, Mr. Chairman. I just wanted to kind of drill down a little bit on the gentleman's pay when he was a contractor. Your report says it was $471,875. Is that correct?
That was not the wages that he took home. That includes housing, which was not paid to him.
Okay. So if you take what he was actually paid and if you were to compare it to what he got paid as a government official, but then you also added what he got paid as a government official, if you added to that his health care benefits, his life insurance, his FICA payments, all those kind of things, how does it compare?
Well, he started out, this is according to his own information to us, what he told us, that he started out making effectively $72 an hour. And he monetized all of the benefits that you mentioned, including retirement, payroll taxes, annual leave, holiday time.
So was it equivalent?
Then it became $105 an hour, a difference of about $33 an hour.
Was his pay as a contractor equivalent, greater than or less than his pay as a government employee?
$33 higher.
Per hour?
Correct.
And that includes...
I'm sorry. Yes, per hour, yeah.
And that includes the housing that he had, right?
No, that does not.
Okay, so on top of that there was housing.
Correct, which did not go to him personally.
Okay, so tell me about the housing. What were the housing arrangements like?
So the housing arrangement went through the Fishery Service, the National Marine Fishery Service. They had a contract called BOQ contract that went with a number of residential buildings in the neighborhood near their office, where senior executives who were on temporary detail to their headquarters would stay.
So he did not own this housing?
Correct.
And would the housing have been empty had he not been in there?
I assume so.
So it really didn't cost the government anything for him to use that. It was probably a good... I'm just asking out of curiosity, is that a good use of the government's resources to put him in open housing?
I think they would not have had to pay for that particular housing. I don't know, but
okay.
I don't know whether they would have had to pay for that particular unit if he had not used it.
That would be very useful for us to know. Out of curiosity, the deputy CFO's supervisor, the CFO, was aware of these arrangements, correct?
Well, we believe so. We heard witness testimony, and there is some evidence to suggest that he did approve it. He told us.
You don't have any paperwork that he approved it?
I am not aware of a specific document that he signed approving it. I do not know of that.
But his testimony indicated that he approved it?
His testimony said that he did not approve it and that he would not have.
So he didn't approve it, but he must have known it was going on if this guy shows up the day after he retires as a consultant.
He knew about the consulting arrangement. He says he did not know about the housing part.
Okay.
But other witnesses told us that he did know, including the senior official himself.
The senior official, not the senior official, the deputy CFO was working with the CFO to make sure that he could come back as an employee immediately following his retirement, as a contractor immediately following his retirement. Is that correct?
Correct. It was at the request of his supervisor, yes.
Now, what about the supervisor's supervisor? If we go up to, say, Chief of Resources and Operations Management at NOAA, Mary Wiley, was she aware of it?
I do not know. I do not think it went up higher than, we don't have evidence that it went up higher than the supervisor.
Did you ask that question?
I'll have to get back to you on that. I believe we did. I will get back to you on that.
Okay, so this is very, very relevant to us because the gentleman clearly, according to your case here, he wrote a contract that he then benefited from. I think we're all in agreement that that's problematic. But if the people above his chain of command, how high up did they all know about this? Then we're talking about systemic problems, and that's a whole nother level of issue that we have to deal with as a government, not just within NOAA, but as a government. This is an issue probably government-wide. I'm about out of time, Mr. Chairman. I'll yield back.
Thank you, Ms. Bridenstine. The gentlewoman from Oregon, Ms. Bonamici, is recognized for her questions.
Thank you very much, Mr. Chairman. I want to start by making a statement that I certainly don't condone misconduct or violation of rules or laws or misuse of government resources, and I doubt that anyone on this committee would disagree with that. People should be held accountable, no question. But I have to say I'm disappointed in the way this hearing started this morning. The two attorneys, the attorneys for the two gentlemen who were here earlier, Mr. Byrd and Mr. Harone, had notified the committee that they would be asserting their constitutional rights under the Fifth Amendment and that compelling their attendance would be to simply embarrass them. This all could have been put on record with a statement and the point made, but instead, unfortunately, these people were subpoenaed here to make this hearing into, unfortunately, what turned into political theater, and that's unnecessary and unfortunate. Again, the point could have been made without what happened this morning. Mr. Greenblatt, I'm glad you're here this morning.
Would the gentlewoman yield just for a second?
Yes, Mr.
In regard to her comments that she just finished, I hope she will check with the House General Counsel, and if she does, she will find out that we proceeded exactly as was recommended. And if she disagrees with the way we started our hearing today, then she disagrees with the House General Counsel, and I hope she'll take up her comments with him.
Thank you, Mr. Chairman. Mr. Greenblatt, the IG's findings on this matter were referred to the Department of Justice. I believe you said the U.S. Attorney in Maryland. How was that referral made? Is there a form letter or?
By phone.
By phone. So is there a record of that somewhere?
I documented in an email to the rest of my team and my supervisor at the time.
Okay. And what was the response of the U.S. Attorney in Maryland?
They declined to prosecute the matter, to pursue it.
And did they send that in writing?
No.
Is that typical that something like this is done over the phone?
Yes.
And did they indicate a reason why they were declining to pursue this?
I think there are a number of reasons. I do not want to speak for them. I think, if you want their answer, I would suggest you go to them. But what I understand is that part of it is the delay that we had talked about earlier on when the events occurred and when the referral was made, but also the involvement of the supervisor. I believe, in their view, affected whether they would pursue it or not. That's me talking.
Okay, and so was that what was said to you in the email or the response back? There was no email coming back from them, did you say?
No, it was
just a phone
call.
conversation.
Yes.
Is that what they told you in the phone conversation, or is that what you
I remember discussing those things, and that was reflected in my email as well.
Thank you. Now, there may be some confusion about whether Mr. Harone acted by himself to write his statement of work and receive temporary housing as part of his post-retirement contract, or whether he was assisted in these acts, which very well may be wholly inappropriate, by others at NWS. My understanding is that another NWS official told him to write his own statement of work, and another helped edit it, and there were multiple meetings with his supervisor, Mr. Byrd, and others while working out the details while he was a government employee. Is that your understanding?
Yes, and we reflected that in our report.
And is there any evidence that Mr. Harone did not do the work he was paid to do?
No.
So he actually did. He worked as a consultant.
We believe he was there when he said he was there. We have no reason to believe he wasn't doing things while he was there.
Okay. And is it your understanding that Mr. Harone told multiple NWS officials that he would only come back as a consultant if his temporary housing costs were paid, because by the time he retired, he had moved to Williamsburg, Virginia with his then ill wife?
Yes.
So I also understand that Mr. Hiron's initial short-term contracting agreement was revised at least 6 separate times over a 19-month period. So in correspondence with the IG's office, Mr. Hiron apparently has stated that NWS could have modified or not renewed his contract at any times, but any of those times, but chose not to. Is that your understanding as well?
It was modified 8 times. It was initially, I think, a 3-month contract, and it was extended over all those modifications to 21 months until he was terminated.
And is there any evidence to suggest that either Mr. Hiron or Mr. Byrd were covering up or trying to cover up the fact that Mr. Hiron was working as a contractor?
No.
And was there any indication that they were trying to cover up the fact that Mr. Hiron's housing allowance was being paid by NWS while he was a contractor?
Well, with regard to his supervisor at least told us that he viewed that to be inappropriate and would not have approved it. So he would have had concerns about it. Others also told us that they had concerns about it. For example, the fisheries service that ran the housing contract said that they would not have approved it. They thought he was a government employee at the time. And so because that housing was reserved for government employees, they thought he was eligible for it in that regard, and they would not have approved it. This is the one individual who was responsible for that contract, would not have approved that had she known that he was a contractor, not an employee.
But did you see any evidence that Mr. Hiron or Mr. Byrd were trying to cover up the fact that he was a contractor?
No.
Thank you. I'm out of time. I yield back. Thank you, Mr. Chairman.
I thank the gentlewoman for her questions, and we will now go to the gentleman from Ohio, Mr. Johnson, for his.
Thank you, Mr. Chairman. I appreciate the opportunity to ask questions, and Mr. Greenblatt, thanks for being with us today. Mr. Chairman, I've heard questions and comments related to is this an institutional failure versus individual wrongdoing? Yes, I serve in Congress now, but I served in the U.S. Department of Defense and the Air Force for 26.5 years, and one of the things that the core values of the United States Air Force was integrity first. That means you tell the truth. That means you don't cheat. That means you don't lie. And that means you don't take things that don't belong to you. There's a basic sense of right and wrong that I think the American people have a reasonable expectation that people within our federal government are going to adhere to. So I'm very concerned about what we're talking about today. Can I have the first slide, please? Mr. Greenblatt, this slide is an email from Donald Huron to Robert Byrd. The subject is the SOW and proposed hourly rate, dated March 26, 2010. In this email, Mr. Huron is informing his superior, Mr. Byrd, that he had edited the initial contract for his employment as a consultant. In the email, Mr. Huron suggests that he proposed an hourly rate of pay for himself. Were you surprised to see this email?
Well, this is the problem that we found with the contracting process, certainly, was someone engaged in writing their own future contract that would involve their own wages. That's Federal Service 101. You don't get involved in matters that will involve cash going to your bank.
That affect you financially.
That's right.
Absolutely. Should Mr. Huron, in your opinion, have known that it was inappropriate to draft a contract for his own employment and establish his own hourly rate? Should he have known this?
Well, we believe so. I think that was the conclusion in the report, that that's a basic tenet of federal service. Like I said, you don't take part in matters that affect, your own bank account. And he was a long-time federal employee, 38 years. I'd be hard-pressed to believe that there was no training, no ethics guidance at any point along the way.
Do you know of the specific legal or ethical violations that are implicated by this email? Are you prepared to tell us that?
Well, it certainly implicates 18 U.S.C. 208, which is the criminal conflict of interest statute, and we discussed that in the report, which says you can't personally and substantially participate in a matter that has a direct and predictable effect on your financial interests.
Okay.
And so this, I think, meets that standard.
All right. According to the email Mr. Huron's superior, Mr. Byrd, wrote, he said, Don looks good in general. So based on this email, do you believe that Mr. Byrd facilitated in putting this contract together?
Absolutely, certainly approved it. He requested that Mr. Huron take these actions. So, and we say as much in the report.
How concerning is it, and you've already answered it a little bit, but how concerning is it to you that this exchange occurred between the CFO and the deputy CFO of the agency, the two that are responsible for the agency's finances? How concerning is that to you?
Well, I think, as we said, these are folks that should have an awareness of the ethics issues at play, and this, at a minimum, reflects poor judgment with respect to that.
Could I have the next slide, please? According to Mr. Byrd's transcribed interview with the IG, he had ethical concerns with bringing Mr. Huron back so quickly as a contractor. So, do you have any idea why, if Mr. Byrd had concerns about this, why he didn't raise those concerns earlier?
Well, according to what the supervisor told us, he said that you clear it, he said to his subordinate, the senior official, clear it with the contracting folks and I'll sign off. Mm-hmm. Effectively is what he told us.
As the CFO of the agency, does he have an obligation to notify management that he has concerns about a contract that he personally authorized? Are there any rules in the agency that require that?
I don't know the answer to that question. I think what he told us is that he was reliant on his subordinate and what he believed the contracting officer was telling him that it was okay.
Okay.
So that's my understanding of what he would say. But I don't know the answer to that question.
Very, very concerning. Mr. Chairman, I yield back.
Thank you, Mr. Johnson. The gentleman from Virginia, Mr. Byer, is recognized for his questions.
Thank you, Mr. Chairman. And Mr. Chairman, I respect your leadership and our friendship, but I too am disappointed by today's hearing. I've learned nothing new and nothing that was not already clear in the Inspector General's report. And I look forward to when our Science, Space, and Technology Committee actually gets back to spending more time on science, space, and technology, rather than trying to embarrass NOAA and its many excellent employees over a single instance already handled by the Inspector General. Mr. Greenblatt, we work very hard to encourage companies to hire our veterans. And since so many of these veterans have substantial experience in technology, weapons, war planning, logistics, and more, are we inadvertently creating a revolving door of former federal employees acting as federal contractors? Do you have any idea how many retired military and officers and enlisted now work for federal contractors doing DoD work?
I have no idea. I would imagine it's a large number.
It's a really large number. It's so rhetorical, but thank you for trying to ask it. Mr. Greenblatt, you graduated from Columbia Law, and I understand you're not the House General Counsel. I'm going to focus on the House General Counsel. Wasn't it a waste of time, taxpayer dollars, 37 minutes of this committee's time to insist that two former National Weather Service employees who had specifically declared their intent to invoke the Fifth Amendment show up? I was just sort of baffled by what purpose was served by this low theater. Understanding that the Department of Justice has already declined to pursue any criminal charges against Mr. Huron, do you believe that they were forced to appear in order to create a contempt of Congress charge against them? As a lawyer, does it make any sense to pursue contempt citation for the legitimate exercise of one's constitutional rights?
The last thing I'm going to do is challenge the chairman of a committee that I'm testifying before at the time.
I was hoping you'd challenge the House General Counsel, not our distinguished chairman. So.
I don't know that I'm well positioned to respond, but I appreciate your concern.
Okay, well, I still have a couple of minutes left. The National Weather Service Employees Organization filed a complaint 2 years ago about the pervasive illegal use of personal service contracts at the National Weather Service. Apparently, they have more than 1,000 contractors, the cost of which is over $130 million. Is there pervasive, maybe even illegal use of personal service contracts? And according to the National Weather Service Employee Organization, these personal service contracts are being paid far more on average than the civil service employees, many of whom are doing exact same work. Why are there so many personal service contracts being used rather than filling these jobs with actual federal employees? And the cost of the contracts to taxpayers is considerable. So do you know of anything that NOAA or Commerce is doing to address this concern?
I don't. I think that would be a question better presented to the agency, that in terms of what, if any, steps they're taking. Sitting here right now, I can't tell you whether they have taken any action.
Okay. Thank you, Mr. Greenblatt. Mr. Chairman, I yield back.
Thank you, Mr. Byer. The gentleman from Arkansas, Mr. Westman, is up next for his questions.
Thank you, Mr. Chairman. Mr. Greenblatt, you are familiar with the letter Mr. Hiron's attorney wrote to the Office of Inspector General refuting claims that your office made in its recent report detailing the contract misconduct. In that letter, Mr. Hiron's attorney states that Mr. Hiron, quote, followed his boss's instructions. He had no experience with federal contracting and had to rely on the advice provided by officials who are experts. Mr. Greenblatt, do you believe Mr. Hiron had no contracting experience, given that he was the Deputy Chief Financial Officer and worked at the National Weather Service for 38 years?
What I can speak to is what I know from the evidence, and the email traffic seemed to show some level of facility with the contracts, but this is really not about the contracting issues and knowledge of the FAR, which that letter gets into. It's more about the conflict of interest, the ethics of it. That is the issue here, not the procurement process, but rather whether he was involved in a matter that affected his own bank account. And that's the problem here. And I think that is not, I think it is reasonable to believe that he should have known that.
So following that on the conflict of interest, do you believe Mr. Hiron should have had the foresight to know the arrangement he was orchestrating was improper and he could have walked away from it at any point?
Right. I think at a minimum he just could have talked to an ethics official. I mean, there are ethics folks that are available to talk to and ask. And that's what I would have, that's an easy step that he and every federal employee can do.
All right. And his attorney states that he did not take steps to ensure housing was provided for him in his post-retirement arrangement. Do you agree with that statement?
Oh, I think the evidence is quite clear that he was actively participating in securing housing for him after he returned as a consultant.
And his attorney also claims that Mr. Hiron would have obtained no contracting experience during his tenure at the National Weather Service and thus should not have been aware of applicable federal laws prohibiting his conduct related to his post-retirement consulting position. Do you agree with this assertion?
Again, I don't view it as a contracting issue. I view it as an ethics issue. And that's pretty standard federal service ethics rules, that you cannot get involved in a matter that involves money going to your own checking account. And that's exactly what we have here.
Well, obviously, the contracting issues create ethics issues. So he should have known that the contracting issues could create ethics problems.
Well, certainly when he's talking about his own hourly rate and he's negotiating with other federal employees, including his own subordinates, about how he's going to get the housing, which would take away costs from his own costs. Yes, I think that's something that it's reasonable for a senior, long-time federal employee to know that.
Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Westerman. No minority members are here to ask questions, so the gentleman, Mr. Loudermilk, is recognized for his question.
Thank you, Mr. Chairman. And before I begin my questions, I want to thank you for this hearing. And I find myself in a very interesting position because I find myself in a rare instance that I'm agreeing with a minority on something, which was the theatrics at the beginning of this committee. But I must say you handled yourselves with dignity. With the theater environment was created by members of the minority by continually interrupting what you had to do according to the House Counsel by creating an atmosphere of theater. The questions to Mr. Greenwald have gone away from the issue at hand, and it's more about previous management of his office. And in fact, one that actually did address this issue that was brought up by Mr. Byer indicated that this was one incident where, in fact, the allegations involved multiple incidents over a 2-year period. Is that true?
This lasted for 21 months, yes.
Okay. Were there other incidents that were maybe uncovered in your investigation? I read that there were statements such as this is a normal operating practice.
Yes, we got testimony from a number of different witnesses saying that the so-called revolving door of folks leaving the National Weather Service and then coming back was quite common or happened all the time, things along those lines. Yeah.
Do we know if it's common practice for them to write their own contracts before they leave the employment?
That we do not know. Okay. So that's where we're comfortable saying that there was testimony about the revolving door, but I don't know about beyond that.
Okay. Let me ask you a few questions about this case in particular. When Mr. Huron left as a federal employee and he came back, did he have the same office?
We don't know the answer. We got some testimony that suggested he did, but we don't know definitively whether he did have the same office or same computer or phone or anything like that.
Okay.
He did have a NOAA email address.
Okay, but he kept his same email that he had before as an employee?
I assume so, but I don't know that.
Okay, but we don't know if he had the same computer, same phone. There's some testimony that says he did. What benefit did the taxpayers gain from him retiring and then coming back? Did he essentially do the same job he was doing as a federal employee?
I would say that's a question for the agency to respond, but I can give you what we found from the evidence. A number of witnesses told us that, including the folks who replaced him in that position, that they were doing different things, that there was no overlap in what they were doing. Some folks thought, well, at least one person, in fact, one of his successors, told us that they thought it was a personal services contract, essentially for his supervisor, doing tasks specifically for his supervisor. The whole purpose of bringing him back, according to the witnesses, was to transfer knowledge. He had this wealth of knowledge, purportedly, and so in his retirement, they wanted to get that knowledge before he left. We found that there was little of that. According to the witnesses, there was little evidence that there was an actual transfer of knowledge as they had.
Was he being forced into retirement, or did he voluntarily retire?
Voluntary.
He voluntarily retired, and that we have evidence that he participated or wrote the job description, the contract was being written before he left, so therefore it would leave one to understand that this was designed, it was premeditated, that this was actually in place. He knew he was going to retire, so therefore we're going to write the contract for him to come back as a contractor. Is that true?
Yes. Just to add one fact is that he said he would retire, and then his supervisor requested that he come back, and then they engaged in the process of establishing his arrangement.
Okay. So, but it was arranged that this was going to happen. So effectively what he did was give himself, in coordination with his supervisor, a pay raise instead of just staying on an employment.
Yes, they monetized all of the benefits that would not otherwise be available to a contractor.
So what benefit do the taxpayers have of this arrangement?
That's, I think, something you'll have to ask the agency about what exactly he did on a day-to-day basis during that time.
Was he provided housing as an employee when he was actually an employee of the federal government?
Oh, no.
Is it standard practice for federal employees to be provided housing?
No, sir.
So this was highly unusual for him to leave and then come back and be providing housing as a contractor. Is that, to your knowledge, done in any contracts? Or is it common practice?
I am not aware of it, and a number of folks that we spoke with said that they found it to be inappropriate. I'm talking about the witnesses, has found it to be inappropriate. And like I said, the woman who was running that contract from this fishery service said she would not have approved it had she known he was a contractor.
Okay. I think we've established some of the things we need to. Final question: has Mr. Huron or anyone faced any disciplinary action as a result of any of this?
Well, when the OIG identified a number of problems, we approached senior NOAA leadership, and then they terminated the contract on that, I think, the day after we briefed NOAA leadership. So they terminated his contract. But in terms of discipline, I'm not aware of anything.
Okay. Well, thank you, and I'm out of time. I yield back.
Thank you, Mr. Loudermilk. The gentleman from Florida, Mr. Posey, is recognized for his question.
Thank you very much, Mr. Chairman. Mr. Greenblatt, I have a half dozen questions, so I'd appreciate it if you could answer them as quickly as possible so I can get them all in. The testimony today here is almost bizarre. It's almost incomprehensible. I know most people back home hopefully would find it hard to believe that things could be as corrupt as they appear to be. But just to set the record straight in my mind, what was the date that Mr. Huron officially retired from the National Weather Service?
May 2nd, 2010.
Okay. What date did Mr. Haran start as a consultant for the National Weather Service?
May 3rd, 2010.
Under a contract that he essentially drew himself?
Yes, he revised and edited a statement of work that for his own position, yes.
So while he was with the National Weather Service, he made a contract to become a consultant and come back on the date you said?
Correct.
Okay. What was Mr. Haran's compensation during the last month of his service as Deputy Chief Financial Officer of the National Weather Service?
He was paid, this is rough, is $72 an hour.
Okay. What was Mr. Haran's compensation for the first month of his role as a consultant under the contract that he drew up himself for the National Weather Service?
$105 an hour.
Okay. So Mr. Haran retired from the National Weather Service one day and walked back in the very next day as a consultant, making $3,000 more per month, with his housing being paid for, with essentially no change in his day-to-day responsibilities.
I think it's generally a fair assessment, yes. I can go into more detail if you'd like.
Okay, no, that's good. And the taxpayers essentially took a $457,000 hit for that bad behavior, which you have clearly documented, and you've cited the laws that were broken under the conflict of interest laws, and you took this information to the Department of Justice, and the Department of Justice refused to prosecute?
It declined to pursue the matter, yes.
Did they give any reason why they declined to prosecute?
You'll have to ask them about the exact final decision as to why, but from my understanding, I think the involvement of the supervisor was a factor in their decision, and the fact that the issue had happened a couple of years earlier.
And how many employees at the National Weather Service would have their fingerprints on this? If I went back through all the gatekeepers that didn't do their job, all the checks and balances that are supposed to be in place to stop this kind of corruption, how many people had fingerprints on this if I was to go back and have everyone looked at?
Sitting here right now, I would say the number is probably in the 5 or 6 range.
Okay.
It was not extensive. It was not 20 or 30 people involved. I think it was probably about 5 or 6.
And the whistleblowers have indicated that this is customary behavior?
Well, the witnesses that we met with told us in our sworn interviews that folks retiring and then coming back to the Weather Service was commonplace or words of that variety.
Okay. Mr. Chairman, I want to thank you for bringing this to our attention. For too many years, this kind of behavior has been swept underneath the rug. And Mr. Greenblatt, I want to thank you for your honor and the way that you have represented the taxpayers back home, for your forthrightness, and I hope there's many more people like you out there. I'm a little bit chagrined that some people are more interested in making sure the two culprits were not embarrassed in this committee. Of course, we heard the same kind of comments about Lois Lerner, how unfair it was to embarrass Lois Lerner, who clearly was corrupt as the day is long, targeting political enemies. That's just not the kind of administration that the people in this country expect. And whatever it is that motivates you to do the job that you're doing, I just hope and pray for the future of our country and for future generations that there's more out there like you. God bless you. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Posey. The gentleman from Texas, Mr. Weber, is recognized for his questions.
Thank you, Mr. Chairman. Mr. Chairman, thank you for holding this hearing. Thank you for the way that you've held this hearing. Thank you for the way that you've responded during this hearing. I find it pretty ironic that the minority who have decried the amount of money that this committee wants to authorize as we go forward takes issue with the fact that in a period when we have $18 trillion and we're trying to make the agency as accountable as we can, that they are spending taxpayer dollars appropriately, that they're decrying the fact that somehow we're trying to make them be better money managers. We have a fiduciary trust from our constituents. I applaud you for wanting to do the right thing on behalf of the American people, and I appreciate you holding this hearing. to the gentleman Loudermilk, my good friend, when he asked the witness what benefit did the taxpayers get, I guess I would respond, they got to say a very high and hearty thank you, good job to this guy by paying him not twice, but 2.5 times what he was getting after he retired. I hope he feels like they sent him off with a good farewell and a job well done and a lot of money in his pocket. That's my politically incorrect statement. Thank you, Mr. Chairman. Now, Mr. Greenblatt, you had formal training. I didn't read through your bio. I got here late. So you had formal training as a lawyer, right?
I did.
Right. And you have mentioned a couple of times here that I think it was Public Service 101 or a Federal Service 101. You don't get involved with the money that you're going to be getting paid. You don't get to make that decision. How long have you been on the job where you are?
In my current position, I've been here for a little more than a year. I started in May 2014.
Okay, good. So you got trained. How many violations of this magnitude have you seen yourself?
It's hard to quantify magnitude. I have seen other conflicts of interest cases. When I was at the Justice Department Inspector General, I worked on a number of conflict of interest.
Let me make it easier for you. Have you ever seen somebody retire and get paid 2.5 times what they were getting?
No.
Okay. That pretty well speaks for itself. Do you get training on how to recognize these violations? Did you get training?
Mostly on-the-job training,
training.
Yes, there is training on ethics guidance frequently.
Do people in the agencies, NOAA, i.e., National Weather Service, should they receive some kind of the same training?
Well, I believe everyone, all federal employees receive ethics training, periodic ethics training, depending on the agencies and whatever components they're in. So they get that. I don't know about ethics training in terms of investigations, but
sure. But they know. I mean, if you were a betting man, I'm going to ask you a very subjective question. Would you bet that this guy probably knew that, hey, this doesn't pass the smell test?
Well, I think we found as much in our report, saying that he should have known. I mean, working in the federal government for nearly 4 decades, I'd be hard pressed to believe he.
So he didn't get training in contracting, his lawyer said. But I mean, he should have had training in common sense and right and wrong. I mean, even his parents should have taught him that. Wouldn't you agree?
Well, beyond that, yes, but beyond that, I would imagine there was over the 38 years extensive ethics training, especially for a senior official.
I don't mean to pry, but you get paid a salary. Does the government collect taxes from your salary?
A wee bit, yes.
Do they? Okay. Are you appreciative of the fact that you've got a committee here that actually looks after taxpayer dollars and doesn't want to pay retiring employees 2.5 times what they were making in taxpayer expense?
Yeah, I do appreciate the concern.
Yeah, well, I wonder what your motivation for being here was. So you're a fiscal watchdog like the chairman here is. What I noticed in your report, you said that there were several government officials beyond the subject of our investigation shared responsibility, you believe. Several being 3, 4, 5?
I would identify 3, yes.
You identify 3. And I didn't get a chance to read your report. Did you identify them?
We identified the supervisor. Well, we didn't identify anyone. That's just as a threshold issue. We didn't identify anyone for privacy reasons. So we didn't identify in terms of by name.
Okay.
But I did identify by identifying them as an individual.
But if you wanted to send a signal to the agency, because you also said that there's a quote in here that says federal employees returning as contractors once they retire, quote, happens all the time, end quote. If we wanted to send a signal that this is unacceptable, should we subpoena those 3 in here? I mean, I'm sure 2 of them have already been here in some short fashion. Should we be looking at the others that were involved and subpoenaing their testimony as well as a deterrent, if nothing else?
I wouldn't want to, guide the committee on what it should do.
Yeah. But as a taxpayer, we've already established you get paid and the government takes taxes out, and you appreciate this kind of oversight, right?
Of course.
So I'm going to take that as a yes, Mr. Chairman. I yield back.
Thank you, Mr. Weber. There being no more members to ask questions, I want to thank the witness for his testimony and also members on both sides for their questions. Today's hearing was an opportunity for Mr. Huron and Mr. Byrd to explain to us why taxpayers picked up the tab for an allegedly improper contract worth nearly $500,000. Unfortunately, both former senior officials chose a path of non-cooperation and refused to speak with committee staff voluntarily and only appeared here today under subpoena. In order for the committee to get the information it needs to conduct appropriate oversight of this issue, our investigation will continue. The committee will persist in seeking answers from Mr. Huron and Mr. Byrd, and the committee will conduct oversight to determine if these types of actions are common at the National Weather Service. The American taxpayers deserve answers, and we intend to pursue this issue until we are certain that taxpayers' interests are protected. I am disappointed that neither Mr. Huron nor Mr. Byrd chose to testify today. The witnesses are subject to recall, and the committee stands in recess. Thank you all for being here.